Now, in the first session yesterday, we focused on the potential role of domestic law in terms of carbon dioxide removal options in research and deployment. But even in that context, it was emphasized that some of the approaches were also necessarily influenced, mediated, or maybe even directly controlled by aspects of international law. And indeed, some of the carbon removal approaches that we discuss, most specifically those that have potential impact across boundaries or in the global commons, necessarily will invoke principles of international law. However, which laws apply, how they will be applied, whether there's interstices that necessarily demand more legal principles in the future, are all hotly contested questions in this sphere. And today, we have an excellent panel to help us start to unpack some of those knotty issues, which we will continue to engage with, obviously, for many years to come. So I want to introduce Kerryn Brent, who is a lecturer at Adelaide Law School, who will serve as the moderator for this panel. And I want to thank all three speakers. Kerryn and Jan are here at a bloody late time for them in Australia, and Chris is up pretty late also for us. So I want to thank everyone for your presentations, and I will now turn it over to Kerryn.
Thank you very much, Will. Pleasure to be joining everybody here today. I will just briefly introduce my co-panelists here. Jan MacDonald is the New Star Professor of Environmental Law at the University of Tasmania School of Law, and her research spans the legal and policy dimensions of climate change adaptation law, including coastal management issues and resilience thinking. And I'd also like to introduce Dr. Chris Vivian, who's currently a co-chair of the GESAMP Working Group 41 on Ocean Intervention and Climate Change Mitigation, formerly what many of us would recognise as the Working Group on Marine Geoengineering. And it's our pleasure to talk to you here today about the international legal dimensions of marine CDR. And the way we're going to proceed is we are going to start with a context framing, contextual framing, where we will start by looking at the current legal framework for the governance of CDR in international law. And then we're each going to present on pathways for future governance. Chris is going to talk about a concept for the governance of marine geoengineering by the London Protocol in partnership with a global climate engineering instrument. Jan is going to present on adapting the climate regime's flexibility mechanisms to accredit marine CDR techniques. And I will wrap up by talking about the potential for a new agreement for biodiversity beyond national jurisdiction to contribute to marine CDR governance. So without any further ado, I'm going to turn over to Chris.
Okay, thank you. Glad to be here, and I hope we can have a useful discussion that will inform people. So I'll just share my screen. That's not the right one. Just a minute. Not sure, that's the wrong one. It's the one for later. I have to close that. Just a moment. I'll shut that one. Right, okay. Okay, so I was just asked to do a short presentation about marine CDR options of particular concern for international law. And this is a very short number of slides. So what are these? Well, there's been a very rapid development of interest on and research into ocean CDR techniques in the last few years or so. And this has been largely, but not exclusively, in North America and Western Europe. There are now a significant number of such techniques under active development, with some planning small-scale field experiments and some field experiments indeed underway. And these are probably the options of concern for international law, as they are obviously starting to do things in the field, and they could develop into something more significant. And just to note that while there's interest in the capture and degradation of methane, it's not part of CDR, I know, but it's a very important gas, and as we've heard from the IPCC recently, they're suggesting a focus on methane might be quite useful at the moment. But within the marine environment, at least, there don't seem to be any specific proposals being developed. A little bit different in the atmosphere. So what are these options that I think we're of interest in and concern? Well, ocean fertilization is an obvious one. Many of you will have heard about it. There is the London Protocol amendments that we'll hear a bit more about later that deal with it. They aren't in force, of course, at the current time, although the parties that have ratified them and those parties who supported it in the vote in the meeting are sort of in principle bound by it, even if legally speaking it's not absolutely rock solid. Ocean carbon storage in the ocean by macroalgae, which we already heard about in this conference, sinking that into the deep sea, and also depositing of crop waste. There are one or two suggestions still out there to maybe pick up on that one, which is a analogous thing, putting carbon essentially into the deep sea seabed. Enhancing ocean alkalinity is another one that we know about, which is either adding alkaline material to the sea or using electrolysis of seawater. And also there's the coastal spreading of olivine version, which is being pursued currently by Project Vesta, for example. There are proposals also for mineralization of rocks such as basalt under the seabed by injecting CO2 into the rocks so it reacts and locks it up permanently. And then there's this, what we call the ocean pumping ones, ocean upwelling or downwelling, either to cause fertilization, which has been probably the main proposal, but there have been one or two suggestions to do it to cool the surface waters as well. And one of the particular variations of that is a concept from Stephen Salter that maybe you could cool the waters in front of hurricanes to try and take a bit of energy out of them, which is somewhat controversial, but all of these ones I think are potentially in play. They have a bit of difference between them as to what may control them, but that's just how it is at the moment with a legal setup. And just finally, a quick slide to say why I think there's a few others that aren't a concern at the minute. Depositing liquid CO2 in the ocean is one that's been on the stocks for a very long time, but it doesn't seem to be actively being researched currently. Also one that's been proposed, but again, no active research as far as I'm aware, other than sort of academic discussions and papers, is enhancing dissolved refractory organic carbon in the ocean, because that's where there is a very large amount in the deep sea where it's locked up for a long period of time. And finally, of course, enhancing carbon storage in coastal blue carbon systems. Now that one is one that falls under the category of probably already covered by existing legislation. This occurs within national jurisdiction, and therefore it's probably reasonably well covered. And therefore we don't really need to, I think, concern ourselves about it. It's interesting, but it's not one where there's really international legal concerns, I think. And that's it.
Zoom mute button. I'll pick up where Chris left off. Jen and I are both going to talk about the existing international law that might apply to marine CDR. Jen's going to talk about the treaty obligations, but it's important to note that treaties are not the only source of international legal obligations. There's also something called customary international law, and these are unwritten but legally binding and enforceable rules that are formed through sustained and deliberate state practice. And a key obligation in the context of marine CDR is the duty to prevent significant harm to the territory of other states and to areas beyond national jurisdiction, and this includes high seas areas. This is often referred to as the customary law no harm rule, and it provides states with a due diligence type obligation to take steps to prevent significant transboundary harm. The no harm rule is a fundamental principle of international environmental law, and it's also been reiterated in a number of treaty texts, including the United Nations Convention on the Law of the Sea. So what does the no harm rule mean for marine CDR? Well, the no harm rule is triggered by activities that present a risk of significant transboundary harm. So it will only apply to marine CDR activities that present risks of significant harm to the marine environment of high seas areas or to the marine or land territory of other states. So it's therefore unlikely to create obligations for small scale research activities. However, if triggered, the state in question must use all means at their disposal to minimise the risk of harm. This includes conducting a transboundary environmental impact assessment, notifying and consulting with potentially affected states, adopting a precautionary approach, and this means that if the specific scope or nature of a potential negative impact from marine CDR is uncertain, so long as there are plausible indications of potential risks of transboundary harm, states should still fulfil their obligations under the no harm rule. And states also have an obligation under the no harm rule to enact and enforce relevant domestic laws to uphold this obligation. And this aspect of the no harm rule, of a due diligence obligation, was especially pertinent in the recent South China Sea arbitration. And so states within which marine CDR is being researched or whose citizens might be involved in eventual deployment activities should ensure that their domestic laws and monitoring and enforcement mechanisms are sufficient to uphold this obligation. Finally, under customary international law, states can be held responsible and liable for internationally wrongful acts. And it's important to clarify what this means in the context of marine CDR. If an activity by one state results in harm to another or to high seas areas, this is not going to automatically mean that the state in question can be held liable for that harm. You need to establish that a legal rule has in fact been breached. That could be the no harm rule, or it could be a treaty obligation. It's also important to understand that international law is a consent-based system, and states must consent to have any disputes, including liability disputes. Under customary international law, these must be referred, or they must consent to refer them to an international court or tribunal. And these are matters that will limit the extent to which existing customary law liability and responsibility mechanisms can contribute to marine CDR governance. I'm going to stop sharing and over to you, Jan.
Thanks, Kerryn. I'm going to just talk briefly about the international treaty framework for marine CDR as we venture into the largely uncharted waters of large-scale marine CDR deployment. I think it's important to think about what kind of lifebuoy international treaty law offers us. Kerryn's talked about customary international law, and obviously that applies in the absence of specific treaty obligations. But in fact, many CDR activities in the ocean will be subject to a whole number of existing treaties and protocols, even though those agreements haven't necessarily been developed with CDR in mind. So the major international frameworks that are primarily implicated are the Convention on the Law of the Sea, the London Convention on the Prevention of Marine Pollution by the Dumping of Wastes and its successor agreement, the London Protocol, the Convention on Biodiversity, and of course, the UNFCCC. There are obviously also important sectoral and regional conventions as well. But if I can just very briefly map for you the key elements of these major framework agreements, and then I want to do a deeper discussion of the particular importance of the climate regime in governing marine CDR. So UNCLOS provides the broad framework for obligations on states for activities conducted in the oceans. Has a membership of 168 parties, so it has very, very broad application, essentially universal application. For our purposes, the important aspects of the convention are the obligation to protect and preserve the marine environment, some specific obligations relating to preventing and minimising marine environmental pollution, which for the purposes of the convention is defined as introducing substances to the marine environment. So if you think back to Chris's identification of relevant CDR applications, iron ocean fertilization and alkalinisation would fall within that definition of pollution because they involve introducing substances, but enhanced upwelling probably wouldn't fall within that definition. It would fall within that broader obligation to preserve and protect the environment, but not the specific obligations relating to pollution. And then there are particular rights and obligations regarding scientific research in the marine environment. And I think interestingly, for our purposes, thinking about future pathways for governing marine CDR under international law, the Convention on the Law of the Sea requires parties to ensure that any new international or domestic rules for, in our case, marine geoengineering governance are compatible with the terms of UNCLOS. So whether or not we develop sub-agreements under the London Protocol or under the Paris Agreement, UNCLOS expects them to be consistent with the terms of that overarching agreement. Just very briefly, UNCLOS does have special provisions or particular provisions relating to exploring and exploiting the deep seabed, and this might have particular implications for the macroalgae and iron ocean fertilization, where there's an expectation of the use of the deep seabed for these storage purposes. Part 11 of UNCLOS provides that all resources in the deep seabed are the common heritage of mankind, and that any regime for exploiting that seabed must ensure that all states benefit. So in terms of regimes that might incentivize the use of CDR by enabling parties to claim credit for it, these benefit sharing obligations would need to be taken into account. And the seabed provisions of the Convention on the Law of the Sea apply to obviously state parties, but also obligate state parties to take responsibility for the activities of private enterprises acting within those areas as well. The London Protocol provides more specific rules relating to the dumping of waste or other matter into the ocean. Again, its operation is technically restricted to activities that involve the placement of matter into the ocean. So it wouldn't necessarily at the moment cover all of the marine CDR activities that Chris talked about. But the thing that's significant about the London Protocol is this 2013 amendment, which represents really the first attempt by the international community to develop a binding framework to specifically govern marine geoengineering. It doesn't, in its terms, expand the protocol's scope. It applies to marine geoengineering activities that involve the placement of matter into the sea. And at the moment, it's only been accepted by a very small number of parties. I'm not going to steal Chris's thunder any further on that. He'll talk in more detail about that framework, but it's clearly a very important part of the international law puzzle when it comes to pathways for particularly frameworks that address the environmental risks associated with some of these marine CDR techniques. Finally, the other relevant framework convention is the Convention on Biodiversity. It obligates parties to cooperate for the conservation and sustainable use of biodiversity in areas beyond national jurisdiction and on other matters of mutual interest. And Kerryn will speak briefly about the implications of the development of the BBNJ agreement as it may pertain to CDR regulation. There have been a couple of noteworthy developments under the CBD, which, although they haven't been binding, have certainly influenced recent perceptions regarding the permissibility of interventions like carbon dioxide removal. They haven't been specifically related to the marine environment, but they definitely do apply to the marine environment. So in 2008, the Conference of the Parties urged national governments to ensure that ocean fertilisation activities don't take place until there's an adequate scientific basis on which to justify those activities, which would include a risk assessment. And a couple of years later in 2010, the parties agreed to a non-binding decision requesting states to refrain from any geoengineering activities, which is much broader than simply CDR, that could adversely impact biodiversity. So that's often referred to as a de facto moratorium. In some of the discussions that you see that are particularly critical of geoengineering, it refers to it as a ban on geoengineering activities. At the moment, both of those statements from the CBD are non-binding. They have hortatory effect, but they do indicate at the moment a position on the part of the Convention on Biodiversity that is certainly highly cautious of moving in that direction without appropriate safeguards and risk assessments. So I'd like to turn now to consider the role of the climate regime in governing marine CDR. And I think it's fair to say that in the big scheme of things, what we're likely to see is the Paris Agreement taking a larger role when it comes to the role of large-scale deployment of CDR rather than the regulation and oversight of R&D. But it is important to connect the two. And if I could just step back for a moment and reflect in broad terms on what we need an international law regime to do overall in order to ensure the long-term safety and acceptability of marine CDR deployment. So we need an international regime that will create incentives for developing these technologies and deploying them. At the moment, they're largely untested, so we need some incentive to fund the R&D, and that is generally going to assume either that countries can use these techniques to count towards their own nationally determined contributions under the Paris Agreement, or they can undertake activities that can then be traded and for which they can earn credits. It's the challenge that we face at the moment is that these activities are, for a large part, more expensive, but we know that in the longer term, they're going to be necessary for any kind of net zero ambition under the Paris Agreement. So what we're likely to need is parallel obligations where countries are expected, according to however we resolve questions of equitable responsibility, obligations to both undertake emissions reductions, but also to start the process of carbon dioxide removal as well, so that there are two separate types of commitment to mitigation within NDCs. There are some jurisdictions that are already doing that, but it's not an expectation at this stage. So we need an incentive framework, but the incentive framework needs to be designed in a way that provides methodologies for accounting and quantification of removed carbon that doesn't undermine the overall mitigation ambition of the Paris Agreement. So we have to make sure that we avoid the moral hazard of relying on carbon dioxide removal to avoid emissions reductions in the short term. We also need a governance regime that will assess and then manage the social and environmental risks and the associated conflicts that may arise as a consequence of deploying marine CDR. And whether you view this as part of the first incentives requirement or a standalone element, we need a governance regime that establishes robust, accountable and transparent processes for monitoring, reporting and verification. So why is the climate regime in particular a really critical part of this governance regime? Well, aside from the primary goal of marine CDR being to remove carbon dioxide from the atmosphere and to promote mitigation, the climate regime is where we find mechanisms that currently don't exist elsewhere to implement the kind of financial transfers and financial arrangements that can mobilize CDR potential, particularly in countries that are not able to afford any kind of CDR program, be it in R&D or in upscaling at this stage. So there is the potential under the climate regime to actually put these incentives in place by having the opportunity for countries to count towards their own NDCs or to sell credits or to transfer credits to other countries. The enhancement of sinks is expressly contemplated under both the FCCC and the Paris Agreement. The FCCC speaks of promoting and cooperating in the conservation and enhancement of sinks and reservoirs, including oceans, coastal and marine ecosystems. Sinks and reservoirs are both defined very broadly, and those definitions are adopted in the Paris Agreement as well, which recognises the importance of conserving and enhancing sinks, obliging parties to pursue mitigation measures with the aim of achieving their NDCs, but to do so in a way that conserves and enhances these sinks and to take specific action to conserve and enhance sinks. And Article 4 talks about the importance of striking a balance between emissions reduction and removals by sinks. So contemplating that both of these activities will be critical in the future. So it seems fairly clear that marine CDR activities that are undertaken within a country's territorial waters and arguably their EEZ could be counted towards their own NDCs and then potentially transferred using one of the cooperative mechanisms I'll talk about in a moment. What's less clear is the status of carbon dioxide removal credits that have been earned as a consequence of activities that have been conducted on the high seas, and whether or not they should be claimable by any country. And I'll return to that issue very briefly towards the end. So in terms of what mechanisms might be used to promote the upscaling of marine CDR, Article 6 establishes the framework for cooperative approaches to drive higher ambition. And the terms of this article make clear that it can't be used where investments in CDR would detract from emissions reduction. So there's this clear emphasis on rapid, deep emissions reduction plus investment in CDR, R&D and deployment. Having said that though, there's still enormous uncertainty around how these Article 6 mechanisms are going to operate. Many of you would already know that it's the only part of the Paris rulebook that's not yet finalised. There's been considerable disagreement over some key aspects, particularly questions relating to double counting of emissions reductions, or in our case, carbon dioxide removal credits. So let's briefly consider each one of these mechanisms. I'm mindful of time. So the first is this concept of internationally transferred mitigation outcomes, or ITMOs, under Article 6.2. Using ITMOs, a host country that generates credits through marine CDR can relinquish those rights, the rights to use those credits towards its own nationally determined contributions in exchange for payment from another party. It assumes that the host country would have been eligible to use those credits against their own NDC. So again, those issues of where the activity is conducted come into play a little bit. There are some critical aspects of this provision of the Paris Agreement that haven't been resolved. It's critical that measures avoid double counting by using a corresponding adjustment between parties, but at the moment, how that might work has not been made clear, and it's going to need specific rules for CDR. If double counting is ruled out, there are still concerns that having the potential for these kinds of ITMOs could encourage host countries to deliberately set their NDCs at a very low level so that excess credits can then be sold off to other countries rather than applying them to meet higher levels of ambition. There's also concerns, particularly in a marine CDR context, about the impermanence of some biological storage techniques. And there's suggestion that none of the trading mechanisms in Article 6 are actually appropriate for those biological storage marine CDR techniques, and that they're much better dealt with as a non-market measure. So these issues may make it quite difficult to use this Article 6 technique when it finally gets up and running. There are some people, therefore, who suggest that Article 6.4's sustainable development mechanism could become the natural home for mobilising carbon dioxide removal globally, whether it's terrestrial or marine, particularly given that it's subject to more stringent international oversight and will have methodologies that focus on particular approved projects or activities. So this is the Paris Agreement's successor to the Kyoto Protocol's Clean Development Mechanism. And the idea is that Paris Agreement Party A would fund Party B to undertake a marine CDR activity, and the mitigation, the removal credits would then accrue to Party A. So it's a results-based finance model is one model that's generally talked about in relation to Article 6.4. So the key thing here is ensuring that these kinds of mechanisms deliver an overall mitigation in global emissions and promote sustainable development. For some kinds of CDR, that will be easier to prove than others. So for example, with ocean alkalinization, you could say that it assists in the reversal of acidification, and that will have sustainable development benefits additional to the emissions reduction credits. The Kyoto Protocol's clean development mechanisms, modalities and procedures provide a useful foundational framework for marine CDR methodologies that can quantify the CO2 that's removed by each activity, that can guide us on how to avoid double counting and demonstrate the overall mitigation of global emissions, that can address these issues relating to non-permanence, including provisions specifically relating to responsibility for net reversals and transfer of liability after specified periods. The Kyoto Protocol's land sector accounting rules, for example, explicitly take into account issues of impermanence. So we've got some useful guidance in relation to how these mechanisms might be adapted to a marine CDR context. Issues relating to liability for leakage or seepage, and safeguards relating to the management of social and environmental impacts. Now, I would be the first to say that the best example of safeguards that we've got in this space is probably the REDD+ framework. And we haven't seen great progress on the implementation of the safeguards requirements of REDD+. So there's more work to be done there, but it's just useful to bear in mind that these mechanisms have been in place under the Kyoto Protocol and are ready to be developed under the Paris Agreement, and would be ideal to be then developed and adapted for a marine CDR context. There has been a CDM methodology since 2010 for carbon capture and storage, which addresses a whole range of these issues, and it would provide a really useful starting point. Finally, the Paris Agreement establishes a formal framework for the first time for cooperation where no trade is involved, these so-called non-market approaches. And this could be especially important to govern development assistance or financing to promote marine CDR in developing countries, to do that scale up, to achieve the potential and to demonstrate the verified emissions reductions, or sorry, carbon dioxide removal, so that it could then move towards a market-based mechanism. There are a range of requirements in Article 6.8, but it particularly focuses, and the discussions for the Paris Rulebook at this stage are particularly focusing on areas where there is opportunity for international cooperation. And so the development of processes in conjunction with, for example, the London Protocol could be a very nice sort of case study or pilot project for the development of a non-market approach relating to marine carbon dioxide removal. So to summarise, incentives are needed to justify investment in marine CDR R&D, but those incentives also need to provide safeguards against the environmental and the social risks. What I've tried to suggest today is that Article 6 of the Paris Agreement provides a good basis for governance arrangements that can provide these incentives, that can drive ambition and can embed safeguards. There's I think a strong case for separating NDC requirements for emissions reduction and CDR commitments in order to drive overall mitigation commitments. Where removal can be assessed and verified, we may be able to use some of these market-based mechanisms, but where removal can't be verified or it's still uncertain, these non-market approaches may be preferable and done in cooperation with the other relevant international frameworks. And that's really a nice segue to move to a discussion of the potential operation of the London Protocol, which Chris is now going to discuss.
Okay, just had to unmute. I'll share screen. Ah, can you hear me? Right, good. Share the screen. Okay. So this is a concept that I've come up with for having a partnership between the London Protocol and a global instrument. I've called it a global climate engineering instrument because obviously we don't have one in existence currently. So let's see. Okay, first of all, the London Protocol. I'm not going to try and describe the amendments, and I've got a reference at the end which is flagged here that you can go into if you need to look at the detail. But this, in 2013, the London Protocol parties adopted an amendment to regulate ocean fertilization and to create a mechanism to control other marine geoengineering activities in the future. Marine geoengineering was defined, as you see here, a deliberate intervention in the marine environment to manipulate natural processes, including to counteract anthropogenic climate change and other impacts. Unfortunately, my screen, I've got people down the side that are blocking the screen off. I think I just need to get out of the full screen a minute to try and see the full text. But anyway, you see it includes climate change, but it's not exclusively climate change, which is the point I've made at the bottom. It can cover other things, and it's only for techniques or activities that have the potential to result in deleterious effects, especially where those effects may be widespread, long-lasting, or severe. So it prohibits placement of matter for ocean fertilization and other marine gearing activities unless authorized by a permit. And matter under the London Protocol, and if you look into the detail of the amendment, I think doesn't just refer to substances, it can refer to structures as well. And it also requires assessment, which is the risk assessment that Jan referred to earlier, being required by some other instruments. This is an ocean fertilization assessment framework that was adopted in 2010. Or for other activities, if there are any ones added to the regulatory list, they can be covered by the generic assessment in Annex 5 until such time as a specific one is adopted for that particular activity. So, first of all, there's been quite a lot of criticisms about the adequacy of the 2013 London Protocol amendments to effectively regulate marine geoengineering. I'm not going to read all of these, but I just want you to be able to sort of see there's a whole raft of them, and I'm not disputing the vast majority of them. I would say there are valid points there throughout this set of criticisms, and there's a few more besides, I suspect, one or two papers I may not have picked up. But they're perfectly valid because clearly the London Protocol's whole raison d'etre is protection of the marine environment. It's not there designed to deal with the climate issues specifically. And therefore, it inevitably means it's not going to deal with all of the issues that are flagged up here. So, some potential approaches. A number of authors have suggested some sort of partnership or coordination between a global body responsible for geoengineering and the London Protocol for regulating marine geoengineering, something that I came up with myself at a meeting in January 2009 in Southampton, and a few papers since by Kerryn Scott in 2010 and 2013, and another paper by Haraguchi et al. In 2015. And just a quote here from Scott 2013 that you can see. She suggests that bodies such as the IMO are better placed than the Geoengineering Conference of Parties to develop detailed regulations designed to protect the marine environment and the results of all states. And so she sort of recommends that this is the sort of the approach to go. And that's the concept essentially that I'll outline below. And this is very much an outline at the minute. I haven't tried to develop a very detailed paper on this yet. And I must emphasize I'm not a lawyer either, but I was involved in the London Convention, London Protocol for some 27 years. So I got exposed to an awful lot of legal issues along the way. So I have a little bit of knowledge, although I know a little bit of knowledge can be dangerous, as they say. So my suggestion is that we try and develop a partnership with a global instrument. And at the moment, this is based on there being a global instrument. And this will be applicable for all climate engineering techniques and technologies. I would have to have these general principles, the precautionary approach, which is relatively fundamental, I think, to most parties, although there are one or two states who may not be that accepting of it. And a whole series of principles are needed relative to risk, cooperation, consultation, information, scientific research, economics, monitoring, and so on and so on, EIA, all of these other things. Many of these things really can fall under what Jan was talking about just now about the Paris Agreement and those potential agreements there under the UNFCCC. And such a global engineering instrument should determine in principle what techniques and technologies were acceptable, taking into account their scientific, technical, and societal issues in comparison with other proposed atmospheric and terrestrial carbon engineering techniques. They also would need to set requirements for monitoring, reporting, and verification, something that Jan's referred to already, and the monitoring of the effects of those techniques. The London Protocol parties would only issue permits for those techniques determined to be acceptable by the Global Climate Engineering Instrument, subject to the LP parties' determination, of course, that the marine environmental impacts themselves were acceptable. And you can envisage, in my view, perhaps 4 development phases for ocean climate intervention techniques and the associated national or international involvement or not at the different stages. And I've developed that into 4 stages: preliminary research, initial research, further research, and then finally implementation. And all of this is based on there being a global instrument, which of course there isn't currently. So preliminary research I'm referring to is really just theoretical considerations and laboratory studies, things like modeling. So it doesn't require any international regulation in my view. Initial research is more proof of concept, very small scale field testing, small scale field testing to explore the potential of a technique, to test equipment, initial studies perhaps for side effects, both positive and negative. And at this stage, this involves mainly small scale field testing, such as the introduction of devices or into the ocean. It might require some regulation based on requirements from the London Convention and the London Protocol or other relevant international instruments, as well as obviously national legislation and customary international law, as we've heard about already. The research will stay in this stage until it's been established, but has at least some potential for climate change mitigation. And I don't see that it requires any input from a global climate engineering instrument at this point, as no climate mitigation is intended or likely. And the issues of concern are mainly going to be marine environmental protection, which is clearly within the remit of the London Convention and London Protocol. So research moves into future research stage when it's been established that there does seem to be some potential there for climate change mitigation. It'll involve larger scale field testing, detailed exploration of implementation issues such as monitoring and verification, attribution of climate change mitigation, and finally build up perhaps to pilot scale field testing if it still seems to be likely to be useful, to establish the feasibility of the technique in all scientific and technical respects. It would require national regulation under the requirements from the LCLP and the other relevant international instruments. While it wouldn't require regulation, in my view, for climate mitigation, since there's still no mitigation intended to be carried out, this stage would require guidance from a global instrument to the LP and its parties. And that guidance would cover issues that would need to be addressed in this stage, so that it can be, the global instrument would be able to thoroughly assess a technique to see whether or not it is deemed to be or could be acceptable. And that would then lead either to acceptance or perhaps prohibition, depending on the outcome at that stage. So implementation is, having gone through all those other stages and got some in principle acceptance, you've got to have an approval in principle from the global instrument. You need to finalize all the technical details and the necessary permissions, licenses, etc. obtained, and the relevant, all the other consultations that are important. It certainly requires national legislation, regulation, and any other relevant international instruments will have to be complied with. And the LP and its parties will have to undertake to implement the requirements from the global instrument in terms of permitting, licensing for things like monitoring, verification, attribution of effects, and so on. And I think this would probably need a formal agreement between the AOP parties and the global instrument to make it actually work properly. However, of course, we're currently not in that position at the moment. And there's a whole, what can you do at the moment? Well, in essence, really what I'm saying here now is something that Jan's really referred to, and I'll perhaps need to finish quite soon. So I think I'll just say that I think there may be some scope under the Paris Agreement to develop mechanisms along the lines that Jan said to try and address how we could manage in the absence of a global instrument. There's also a few bits of work by GESAMP and a German program to try to integrate scientific, technical and societal issues, which is be an important aspect that has to be dealt with. And so at the moment, while there isn't any explicit agreements, LP parties, of course, since they've signed up to the protocol, and also those who have ratified in principle have to abide by that, as well as abiding by all the international law that exists, of course, today. So I think, and I've got a whole load of references at the end. I don't expect you to read those now, but they're there for afterwards for anyone who wants to go through some of the literature that's behind some of the things that I've said. That's it. Sorry, I'm just drying up a bit.
Thanks, Chris. So I'm going to wrap up by talking about the potential for a new agreement for biodiversity beyond national jurisdiction to also contribute to the governance of marine CDR under international law. And for those of you who are not familiar with this agreement, negotiations are presently underway to establish a new treaty under the auspices of the Law of the Sea Convention, aimed at the conservation and sustainable use of marine biodiversity in areas beyond national jurisdiction. This agreement is often referred to as BBNJ for short. Formal negotiations commenced in September of 2018, and the fourth round of negotiations has now been on hold for over 12 months as a result of the COVID-19 pandemic. It was supposed to be held in August. It's been deferred a second time with the ambition to convene that fourth session as early as possible in 2022. Successfully negotiated, this new agreement will establish new rules and obligations for high seas areas, which make up approximately 2/3 of the world's oceans. And this agreement is not being specifically negotiated with marine CDR in mind. However, it is important to note that a key impetus for the negotiation of a new BBNJ agreement were concerns regarding the governance of another marine technology, being marine bioprospecting. And the draft agreement contains provisions directed at governing marine scientific research, marine technologies, and other human activities that may negatively impact on marine biodiversity in high seas areas. And as such, many of the rules proposed in the draft agreement are pertinent to marine CDR. So many of these provisions are yet to be set in stone. There's a lot of things still up in the air. But in line with the forward-looking theme of this panel, I want to consider the potential for this agreement to contribute to 3 specific aspects of marine CDR governance, being risk management, capacity building, and dispute resolution or settlement. So as mentioned earlier, there are rules under customary international law. It does provide obligations to conduct transboundary environmental impact assessments, but it sets very few standards in terms of the content of those environmental impact assessments. The law of the sea provides similar obligations to conduct transboundary EIAs, but again, it does not prescribe what the content ought to be. The new BBNJ agreement aims to provide states with more detailed processes, thresholds, and guidelines for EIAs. One detail yet to be settled on is whether EIA requirements will only apply to activities that are conducted in high seas areas, or whether they will be triggered by activities that may be conducted outside those areas, but nevertheless impact on them. This would significantly broaden the scope of any EIA requirements and could mean that marine CDR activities conducted in the exclusive economic zone or territorial waters of states that affect high sea areas might give rise to these obligations as well. The new agreement also intends to clarify the threshold at which an EIA would be required. So that's the magnitude and degree of certainty of risk that would necessitate conducting an EIA. Again, there's a lot of options here that are yet to be negotiated. But clarifying this threshold is important to provide states and other actors with greater certainty as to when an environmental impact assessment is required for activities like marine CDR. Some of the options proposed go well beyond what we see in customary international law and under other treaties, providing states with more stringent obligations. The draft treaty also proposes provisions that would require states to consider cumulative impacts from multiple activities as part of their transboundary EIA process, as well as provide them with ongoing monitoring and reporting obligations. So if the draft BBNJ agreement is finalised and if it enters into force, it will provide state parties with more rigorous EIA requirements compared to the Convention on the Law of the Sea and customary international law. And this could enhance risk identification and management for marine CDR in high seas areas. But it's also important to keep in mind that any such rules will still be general in nature. The objective of any new agreement here is to protect and conserve marine biodiversity, not to govern marine CDR per se. Another key issue that needs to be resolved is the relationship between any new EIA rules under BBNJ and those that are contained in other international agreements, such as the detailed provisions that have already been established under the 2013 amendment to the London Protocol. If a state party to BBNJ has also accepted the London Protocol amendment, that raises the question, which environmental impact assessment rules must they follow for a marine CDR activity? Will complying with the London Protocol requirements also satisfy that state's obligations under BBNJ? So settling this issue is going to be important to promote consistency, avoid confusion, and ensure that the one agreement does not discourage states from becoming party to the other. The next way in which BBNJ might contribute to governance is by providing rules for technology transfer and capacity building. This is essential to ensure that developing states can participate in marine CDR research and activities. It's also important more generally to promote equity in ocean science and to ensure that developing states can take full advantage of ocean science. Part 14 of the United Nations Convention on the Law of the Sea provides general provisions already for capacity building and technology transfer. But these provisions under BBNJ are likely to be more pertinent to the specific goals of that agreement, being the sustainable use and conservation of marine biodiversity in high seas areas. And the rationale behind these provisions is to ensure that all countries, especially developing countries, can fulfill their obligations under the new agreement, including conducting environmental impact assessments and participating in other aspects of the agreement, like the management of marine protected areas. Proposed provisions in this regard include obligations for states to cooperate, modalities of capacity and technology transfer, and a framework for monitoring and review of capacity building by the Conference of the Parties. Such rules could assist developing states to contribute to marine geoengineering and CDR research and enhance their capacity to also contribute to governance. However, I want to draw your attention to one provision that I think is likely to make the most significant contribution in this regard, and that is draft Article 51. This establishes a clearinghouse mechanism. The clearinghouse will primarily consist of an open access web platform and may also include a network of experts and practitioners in relevant fields. And the objective of the clearinghouse is that it will play a central role in the sharing of information, technology, and benefits between states. And this clearinghouse mechanism could provide an important platform for state and non-state actors to share marine CDR data. In doing so, it could enhance research transparency. This data could be utilised by other treaty bodies, including the London Protocol, to inform the development of other mechanisms for MCDR governance. The clearinghouse could also promote cooperation between not only states, but international organisations, NGOs, and private operators. So this is a mechanism, that could benefit a wide range of actors and regimes and contribute to building an enabling environment for marine CDR research. The final way in which BBNJ may contribute to marine CDR governance is by providing a dispute resolution process regarding activities in high seas areas. Dispute resolution mechanisms are important in the context of marine CDR. If something should go wrong, they can provide state parties with a forum to pursue liability claims. However, the significance of dispute resolution mechanisms is greater than merely responding to wrongdoing. Dispute resolution processes can help clarify divergent interpretations of treaty rules and promote greater understanding amongst states concerning their obligations. They also provide an avenue for states to resolve differences peacefully. And in short, dispute resolution mechanisms can be fundamental to the effective implementation of international law rules. So dispute resolution mechanisms under BBNJ could provide states with a means to clarify their impact assessment obligations, their capacity building obligations, and also give them an avenue to peacefully resolve differences and disputes. Now, those of you who work in international oceans governance and have expertise in the law of the sea would know that the dispute resolution mechanisms under that treaty body are unique and are fundamental aspects of it. Yes. And this is because Part 15 of the Law of the Sea Convention provides state parties with compulsory dispute resolution mechanisms. Usually in international law, as I said earlier, states must consent to have a matter heard before an international court or tribunal. A key question is whether states will take and adopt the same approach under BBNJ. They've certainly done this with other implementing agreements like the United Nations Fish Stock Agreement, but this has become a sticking point in negotiations with some states opposed to compulsory processes. So it'll be interesting to see what the final decision will be. So to sum up, BBNJ provides opportunities to enhance the governance of marine CDR activities in high seas areas. It could provide states with more detailed impact assessment requirements than currently exist in customary international law, and it could provide compulsory dispute resolution mechanisms. Most significantly, it could provide that clearinghouse mechanism for information sharing and capacity building. Of course, this all depends on a whole lot of variables, what provisions are in the final text, but also which states decide to ratify this agreement and whether enough states ratify at the end of the day for it to enter into force. But scientists, governance scholars and policymakers with an interest in marine CDR should watch this space closely and engage critically with the negotiation process for BBNJ while it's still ongoing. I'm just going to stop sharing my screen there. And I believe we have a bit of time left over for questions. Will, I can see your hands are up.
Yeah. Okay. Thanks for these presentations. It was great. It's fascinating how dynamic this field is going to be, I think, in the next decade. I had a question for Jan about the question of separate mandates for reduction of emissions and CDR. I was wondering if you thought that might require amending the treaty in some way, or does the treaty provide for it? Because, you know, when I look at Article 4 and it talks about the goal being balancing, right, emissions and sinks by the second half of the century, and it defines mitigation as both sinks and emissions, it seems like the parties have a right to get to net zero by using sinks, and maybe almost an unlimited amount of sinks in theory, right? Is there a way in its provisions to not allow them to apply sinks or to have a separate obligation?
There's not a way to prevent them from doing it, other than to say that there are so many mentions in the agreement of the expectation of highest possible ambition and, you know, highest levels of mitigation. And I think that will make it very difficult for a country to legitimately say, we're doing all we possibly can, but we're only doing it through CDR. So I think that there will have to be, in any country's NDCs, a demonstration of both. At the moment, Australia doesn't draw a distinction between its emissions reductions and the CDR it's doing through wetland restoration, for example. So we are merging those two. It's probably the least of Australia's climate sins at the moment, but I think that I don't necessarily think it would require any kind of amendment to the agreement. What it would probably require is some clarification in the rule book that encouraged parties to do this. And I think it's a question around timeframes. At the moment, there is this expectation that emissions reductions will drive this sort of near-term activity, but that the net zero ambition towards 2050 will require more. And it seems as though it's going to be hard for parties to, it will just be easier in an accounting sense in the NDCs if they can demonstrate this amount through emissions reductions and this amount through CDR. but the impetus isn't there at the moment because we're still at too early a stage in that overall sort of net zero journey. I think as we get closer to the pointy end, it will become perhaps more common. Sweden separates out their targets at the moment. And so what we might see is not a mandate, but a growing practice, and that will then become the expectation.
Thanks.
Nicola, would you like to go next, please?
Sure, I'd be happy to. Hi, everyone. I'm Nicola Clark. I work for Pew Charitable Trusts, and I also am doing my PhD at the University of Wollongong, both on BBNJ. So I loved I was really impressed with your presentation, Dr. Brent. I thought that you really had a great grasp of some of the sort of key and complex issues that are currently under negotiation for the treaty. I wanted to raise one sort of other question that's up for debate, because I'd love to get your thoughts and input on sort of the implications for marine CDR. So specifically, there's one question about decision making when it comes to environmental impact assessments, and within the BBNJ agreement. So there's been a proposal that would have some decision, for example, when an activity is likely to cause significant harm to the marine environment, that would have that decision be left to the BBNJ COP, the Conference of Parties, to take, as opposed to a state-based decision-making process. Of course, this idea, as you might suspect, is very popular with many developing countries, like the Caribbean community, African group, and Pacific SIDS. It is very much not popular with others, like the United States, the EU, Australia, as examples. But I'd love to get your sort of thoughts and reactions on the implications of this sort of decision-making aspect for the risk management of marine CDR.
Thank you for such a thoughtful question, Nicola. I will say that in relation to environmental impact assessment provisions, I haven't turned my mind to that particular issue, but I have been thinking more broadly about who takes responsibility for these processes more generally, and who should. And I think Chris's presentation set out a number of potential phases for at least research of marine CDR activities, which got me thinking that a one-size-fits-all approach maybe isn't appropriate in this context. It might be that it's appropriate for states, in particular for laboratory research, for research that is otherwise going to be contained, or a small scale, may not require more than a state-based approval process, but something that is going to be perhaps larger in scale, ongoing. It might be more appropriate to have a COP-based process. Yeah, very interesting question. Thank you. I guess all that would just depend on what the trigger mechanisms for the EIAs are at the end of the day as well, and how stringent they are going to be. And there's a whole diversity of choice in there at the moment, ranging from relatively high thresholds to thresholds that may encapsulate a much broader range of activities. I'm just looking for hands and whether anyone else would like to raise a question or a comment. Please, Chris, go ahead.
I was just going to follow up on that discussion, and I wondered how that mechanism that Nicola mentioned would interact with these sort of decisions about how jurisdiction of existing bodies their responsibilities will be managed, whether, because in essence, it could be seen as the COP for BBNJ taking away decisions from another instrument, which I think is probably pretty controversial, and I suspect a lot of parties would be not very happy with that. So I just wondered how that might work, if it does.
Look, I think that's another really, I don't have the solution there, Chris, but I think it's another really important question to raise. And I think this is where, again, it's very important for us as CDR researchers, people in this space, to raise these questions for consideration while that negotiation process is still ongoing, because the decisions that are made, the text that is finalised at the end of the day, could have significant implications that it would be, you know, best for our interests to identify and attempt to address before things are set in stone. I can see another hand there from Miranda. Please go ahead, Miranda.
Hey, can you guys hear me? I've just got a brand new laptop, so I'm not sure if things are working. Yes, okay, great. Thanks, guys. It was really interesting. Kerryn, I have a question for you. Under the BBNJ proposed structure, could you maybe tell us a little bit about the plans for stakeholder engagement, if there are any? Are they similar to the CBD? I'd just be interested in knowing if there are any provisions for consultation processes.
Look, I'd have to actually go and have a look at that one, Miranda, off the top of my head. This is my midnight brain starting to kick in. But again, I think it's important to stress that what is there are a number of options. There is a list of different alternatives that could result from negotiations. Something else might result from negotiations. This is a live text in a live negotiation context. But I think that's a really important question to raise. I think it goes back to some of the other comments with regards to what relationship will this agreement have with other international agreements? Will it reflect existing processes? Will it create more stringent requirements? And if so, you know, what do states do if they have to serve two proverbial masters? I wonder if there are any questions in the room to direct at Chris regarding the London Protocol and his recommendations for moving forward in that regime. Please, Miranda, go ahead again.
Sorry, that was still up from before. I actually am working with Chris in the GESAMP group, so I don't have any questions for Chris. I think we talk often enough.
Thank you, Will. Please go ahead, Will. I think you're on mute.
Sorry about that. Don't even have midnight brain as an excuse. So Chris, I was curious when you were talking about creation of a climate geoengineering regime, and I was thinking in terms of interaction with Jan's comments about the Paris Agreement. Is it possible that and maybe optimal that the Paris Agreement take on those obligations given its remit to address climate change, or do you think it would be better to have it be a separate instrument?
Right, well, that's a big question, but most of my own personal thoughts have been involved in international negotiations on probably a smaller scale than the UNFCCC ones by a long way. And also what I've read in the literature from a number of lawyers, they really seem to think that the prospects of negotiating a geoengineering agreement, a broad one, is A, a nightmare, and B, probably would take 10, 20 years to achieve as well, let alone getting it ratified. So my feeling, and I think quite a few other people, is that the best option is to try and use existing agreements rather than negotiate a new one from scratch. And therefore something by doing something, perhaps what I suggested with the Paris Agreement might be seen as an interim, short to medium term sort of idea in the absence of any overarching agreement that could potentially come along later, although maybe it could evolve and become something that would still stand alone itself without having to have a completely new negotiated agreement. So I think realistically, a fully negotiated agreement is, I would guess, even with the best will in the world, 10+ years away at best, and it might be longer. Whereas I think trying to work some mechanisms perhaps under the Paris Agreement would be probably more fruitful, even if it doesn't fully address absolutely all of the issues that you might want a global agreement to address. But perhaps Jan might want to chip in and say what she thinks about that as well.
I was actually just going to say that the benefit of developing methodologies under the, let's say, the Sustainable Development Mechanism, or as a non-market approach, is that you can just focus on a particular technology and develop a methodology related specifically to a particular application. And I think that that avoids a lot of the, the broader issues around calling it geoengineering or, starting from scratch in that respect. The idea that 10 years is a long time and therefore we should go for the Paris Agreement, I'm not sure that it would be less time under the Paris Agreement. I mentioned that there's an approved methodology under the Kyoto Protocol's Clean Development Mechanism in respect of carbon capture and storage. And I'm pretty sure that took around 10 years to negotiate. It took a very long time. So I think either way, it's going to take a while. I mean, we don't even have a Paris rule book in respect of Article 6 at the moment. And then, it's going to be a question of developing these things slowly. But to me, that project or technology specific opportunity to develop methodologies simplifies things. Now, some critics would say that's a problem in that it can chip away at some of the broader systemic problems associated with marine CDR. But I think if what we're trying to do is really combat significant climate problems, then we should be doing as much as possible to incentivize whilst also guarding against the risks and making sure that things are safe. And doing it on a technology by technology basis might be a way of doing that in a more streamlined and simplified way.
Yeah, that seems to me a much more manageable approach. You can be quite more focused on the specifics of the issue, and hopefully would get you there a bit easier than trying to negotiate a complete overall agreement. We shall see.
Thanks.
And then the methodology only has to be used by the parties that actually want to participate in that activity, whereas with a new treaty or a new international agreement, you've got all those issues about membership and all of those other challenges.
And also, you don't need to try and make sure you cover everything, whereas if you're doing it specifically, you know what it is you're dealing with, and that provides a more effective, perhaps, negotiation. Does that answer your question, Will?
Yes, thank you.
I think we have time for one last question. Otherwise, we can wrap up and call it a day or a night, as it were, for us here in Australia. Thank you, everyone, for a very rich discussion and some terrific questions. We hope you enjoy the rest of your day at the conference. Thank you, Will.
Thank you very much, Kerryn. Thank you, Kerryn, Jan, and Chris. And thank you to everyone for your questions. So we are going to adjourn now until 1 p.m. Eastern time. And I hope everyone will come back. Our next panel will focus on some of the specific early movers in carbon dioxide removal projects and some of the issues that they're encountering in terms of the regulatory and legal regime, and some thoughts they have in terms of what's necessary to provide them with certainty moving forward. So as I said, 1 p.m. Eastern time, and until then, thank you very much and goodbye.